Judge calls for U.S. Marshals and FBI to arrest Congress and U.S. President Obama. This is a December 10th article stating that on November 28th, 2015, Alaska State Judge Anna Maria Reitzinger addressed an open letter to all federal agents, including the FBI and U.S. Marshals, to arrest Congress, the President, and the Secretary of the Treasury. She goes into incredible detail on the fraud that's been committed, and this is what she states. Her letter, Anna Maria Reitzinger, Anna von Reitz, November 28th, 2015, Big Lake, Alaska. Dear federal agents, I am addressing this letter in this way because it is my understanding that it will be read by members of both the FBI and the U.S. Marshals Service. It is also my understanding that you have available for examination a wet ink signed copy of the illustrated affidavit of probable cause entitled, quote, "You know something is wrong when," an American affidavit of probable cause, end quote, as backup reference and evidence. Since the publication of the affidavit, a plethora of new supporting documentation and evidence has come to light. We found, for example, that on June 30th, 1864, the members of Congress acting as the board of directors of a private, mostly foreign-owned corporation doing business as, quote, the United States of America Incorporated, end quote, changed the meaning of state and United States to mean District of Columbia Municipal Corporation. Like the 1862 change of the meaning of the word person to mean corporation, cited in our affidavit, these special coded meanings of words render a drastically different picture of the world around us. It turns out that your personal bank account is actually a corporate bank account. The Colorado State Court is actually the Colorado District of Columbia Municipal Corporation Court. If you are shocked to learn these facts, you are not alone. So are millions of other Americans. These changes were made 150 years ago and tucked away in reams of boring meeting minutes and legalistic gobbledygook meant to be applied only to the internal workings of a private governmental services corporation and its employees. There was no public announcement, just as there was no public announcement or explanation when Congress created municipal citizenship known as U.S. citizenship in 1868. Properly, technically, even to this day, this form of citizenship applies only to those born in the District of Columbia, Guam, Puerto Rico, and other insular states, so that there was no real reason to educate the general public about the topic. As Congress was secretively using the labor and the private property assets of these citizens as collateral backing the corporate debts of the United States of America, Inc., there was plenty of reason to obscure this development. At the end of the Civil War, it would have been very unpopular to reveal that they were simply changing gears from private sector slave ownership to public sector slave ownership. You may be surprised to learn that slavery was not abolished by the 13th or any other amendment to any constitution then or now. Instead, slavery was redefined as the punishment meted out to criminals. Look it up and read it for yourself. It remains perfectly legal to enslave criminals, and it was left to Congress to define who the criminals were, because Congress was given plenary power over the District of Columbia and its citizenry by the original Constitution of the Republic, and could do whatever it liked within the district and the Washington, D.C. municipalities. A child picking dandelions on the sidewalk could be arbitrarily defined as a criminal and enslaved for life by the renegade Congress, functioning as the government of the District of Columbia and as the board of directors of the District of Columbia Municipal Corporations. But for starters, Congress simply defined U.S. citizens as debt slaves under the 14th Amendment of their corporations' articles and bylaws, which they deceptively named the Constitution of the United States of America. The actual Constitution was and still is called the Constitution for the United States of America. But most people untrained in the law and trusting what they believed to be the government didn't notice the difference between the Constitution for the United States of America and the Constitution of the United States of America. You are beginning to see a pattern of deliberate deceit and self-interest and double-speaking and double-dealing? And are you also beginning to catch the drift, the motivation behind it? Let's discuss the concept of hypothecation of debt, meaning mortgage of debt. This little gem was developed by the bankers who actually owned and ran the government services corporations doing business as the United States of America, Inc., and as the United States Incorporated. When you hypothecate debt against someone or against some asset belonging to someone else, you simply claim that they agreed to stand as surety for your debt, similar to the co-signing a car loan, and as long as you make your payments, nobody is any the wiser. Normally, it's not possible for us to just arbitrarily claim that someone is our surety for debt without proof of consent, but that is exactly what Franklin Delano Roosevelt and the Conference of Governors did in March of 1933. They named all of us and all our property as surety standing good for its debts, for the debts of their own bankrupt governmental services corporation during bankruptcy reorganization, and got away with it by claiming that they were our representatives and that we had delegated our authority to them to do this for us. The exact date and occasion when this happened and where it is recorded is given in our affidavit. In order to pull this off, however, they had to allege that we were all U.S. citizens and therefore all subject to the plenary power of the Congress acting as an oligarchy ruling over the District of Columbia and the federal territories. They did this by abusing the public trust and creating and registering millions of foreign citrus trusts named after each of us. Under their own diversity of citizenship rules, corporations are considered to be U.S. citizens. So they created all these foreign citrus trusts as franchises of their own bankrupt corporation, used our names styled like this, John Quincy Adams, and placed commercial liens against our names as chattel owned by their corporations as standing as surety for its debt. A group of thugs elected to political office grossly transgressed against the American people and the American states and committed the crime of personage against each and every one of us without us even being aware of it. They couldn't enslave us, but they could enslave a foreign citrus trust named after us that we conveniently didn't know existed. And by deliberately confusing this thing with us via the misuse of our given names, they could bring charges against what appeared to be us and our private property in their very own corporate tribunals, and so the fleecing of America began in earnest. The hirelings had our credit cards and stolen our identities and were ready to begin a crime spree unheralded in human history. They claimed that we all knew about this arrangement and consented to it because we voluntarily gave up our gold when FDR sent his henchmen around to collect it, when, as millions of Americans can attest, people gave up their gold in preference to being shot or having to kill federal agents. They chose life for everyone concerned over some pieces of metal, and for that, they are to be honored. Unfortunately, their decision gave the rats responsible an excuse to claim that Americans wanted to leave the gold standard and wanted the benefits of this new deal in equitable exchange for their gold, their identities, the abuse of their good names as bankrupts and debtors, the loss of a loyal title to their land and homes, and their subjection as slaves to the whims of Congress. According to them, that is, those who benefited from this gross betrayal of the public trust, we all voluntarily left the Republic and the guarantees of the actual Constitution behind, willingly subjected ourselves to congressional rule, donated all our assets, including our labor and property, to the public charitable trust set up after the Civil War as a welfare trust for displaced plantation slaves, and agreed to live as slaves owned by the District of Columbia Municipal Corporation in exchange for what? Welfare that we paid for ourselves, Social Security that we paid for ourselves. The criminality of the U.S. Congress and the presidents acting since 1933 is jaw-dropping, shocking. Their abuse of the trust of the American people is even worse. They have portrayed this circumstance as a political choice instead of an institutionalized fraud scheme that they have presumed that we all went along with it and agreed to it without complaint. Thus, they have been merrily and secretively having us declared civilly dead as American state citizens the day we were born, and entering a false registration claiming that we are U.S. citizens instead. We are told, when we wake up enough to ask, that we are free to choose our political status. We don't have to serve as debt slaves. We can go back and reclaim our guaranteed Republican form of government and our birthright status if we want to. But that requires a secret process in front of the probate court and expatriation from the federal United States to the continental United States, and all sorts of voodoo in back rooms that can only be pursued by the few and the knowledgeable at the best and the blessed. Everyone else has to remain as a debt slave and chattel serving whatever corporation bought the latest version of the corporate persona named after us. So let me ask you, as members of the FBI and as U.S. Marshals, does this sound like something you want to be involved with enforcing on innocent people, or does it sound like something you want to end as expeditiously as possible? The frauds that took root in the wake of the Civil War and which blossomed in the 1930s have come to their final fruition. Employees of the District of Columbia Municipal Corporation and its United Nations successors are being used as jackbooted thugs to throw Americans into privately owned federal correctional facilities when those who need correction, the members of the American Bar Association and the euphemistically named and privately owned and operated Department of Justice, continue to ignore the fact that Americans do have a choice and that by the millions we are demanding our freedom from all these pathetic false commercial claims and presumptions. We are standing up before the whole world and telling these privately owned governmental services corporations to go bankrupt like any other corporation that doesn't do its job and mind its budget. These entities deserve to go bankrupt and worse. They have spent money and credit that was never theirs to spend. They have defrauded millions, if not billions, of innocent people, and they have prevented Americans from claiming their birthrights for far too long. These people, the members of Congress and the various presidents of the numerous United States corporations, have acted as criminals. They deserve to be recognized as such. The members of the American Bar Association have attempted to wash their hands while profiting from the situation and obstructing justice. They stand around shrugging and saying, well, it's a political choice. We don't have anything to say about it. Yet at the same time, they refuse to correct the probate records to reflect our chosen change of political status when we plainly identify ourselves and enunciate our will for them. They too deserve to be recognized as self-interested criminals and accomplices to identity theft, credit fraud, and worse, which is why we have recently issued a $279 trillion commercial obligation lien against the American Bar Association, the International Bar Association, and the Department of Justice. All our assets, our bodies, homes, businesses, lands, and labor have been signed over into the public charitable trust by con men merely claiming to represent us. Then, when we object to their lies and entrapment, they use the same fraud against us as their excuse for bringing more false claims against us and throwing us in jail. Enough is enough. The British monarch and the Lords of the Admiralty have promoted this fraud against us. At the same time, they have claimed to be our trustees, allies, and friends in perpetuity. It's time to clear the way for us to politely, peaceably exit from any presumption that we are or ever were U.S. citizens, willing participant in the public charitable trust, or willing sureties for the debts of any private bank-run governmental service corporation merely calling itself United States or something or other. We repudiate any presumption of private municipal citizenship or obligation to the District of Columbia Municipal Corporation or any successor thereof, and demand an immediate and permanent correction of the civil record to reflect our birthright status as American state citizens. Nunc tunc. As for you, as federal agents, you have a lot to think about. For starters, who really pays your paycheck? Is it the goons in Washington, D.C.? Or does it all come from the American people you are supposed to be serving? Do you believe for one moment that anyone just lined up and gave their gold to FDR voluntarily? Do you believe that anyone gave away all their property and the guarantees of the actual Constitution for the privilege of paying for Social Security? No. Wake up and smell the Java and start doing your real jobs. If anyone complains, arrest him. We are reopening the American common law courts expressly for the purpose of settling disputes related to living people and their property assets in excess of $20 as mandated by the Seventh Amendment. We, the American people, are the ones holding absolute civil authority upon the land of the continental United States, and we give you permission to arrest the members of Congress, the President, the Secretary of the Treasury, and any other politician or appointee pretending to speak for us so as to enslave us and bring false claims against us via this institutionalized fraud scheme. We want it recognized for what it is and dismantled and repudiated to dissuade. Any court that is caught arresting and prosecuting Americans under the presumptions just described to you, such as bringing charges against foreign citrus trusts with names styled like this, John Quincy Adams or Siki V. Trusts like this, John Quincy Adams, or Puerto Rican public transmitting utilities styled like this, John Q. Adams. It is your responsibility to make sure that any individuals being addressed by these courts were actually born in the District of Columbia, Guam, Puerto Rico, or one of the other insular states, and that they are not ignorant American state citizens being falsely registered and railroaded. Do you understand? Is it not completely clear who the criminals are? Your actual employers and benefactors are being attacked and defrauded by criminals pretending to act as their elected representatives and accomplices in black robes who are serving as enforcers of this fraud for profit. This has been happening right under your noses. This whole circumstance has escaped broad-scale public understanding because it was being pursued by private governmental service corporations owned and operated by international banking cartels who claimed that private arrangements were none of the public's business, despite the grotesque and far-ranging impact those cozy understandings have had upon the people of this and many other countries. Let it be perfectly clear to you that the business of these private corporations has become our business because they have operated in violation of their charters, in violation of the treaties allowing their existence, and in violation of the national trust. The American Bar Association and the Internal Revenue Service have both been owned and operated as private foreign bill collectors and trust administrators by Northern Trust, Inc., in violent conflict of interest. They are not professional associations, non-profits, or units of government. They are con artists and privateers whose licenses expired as of September 1st, 2013. The United States Marshal Service is enabled to act in the capacity of constitutionally sworn federal marshals, and we invoke their office and service as such. Failure to accept the public office means rejection of all authority related to us. The same may be said of the FBI. Either you do your job as constitutionally sworn public officers, or you act as private mall cops in behalf of the offending corporations under color of law when you pretend to have any public authority or function. This is the truth, the whole truth, and nothing but the truth. Judge Anna Maria Retzinger, Alaska State Superior Court. I'll give you a link below for this.